Welcome back to Law in Focus, where we dive into the messy, fascinating world of law. I'm Ava.
And I'm Molly. Let's start today with something every caffeine addict has seen at least once in their life. A tall, pastel-colored Arizona tea can with that can't-be-beat 99-cent price tag.
Arizona tea is one of those brands everyone recognizes. Pastel cans, giant size, and that bold 99-cent price stamped right on top. But behind that familiar image is one of the most intense corporate disputes in beverage history.
Arizona started in Brooklyn when childhood friends John Ferlito and Don Voltaggio turned a small beverage business into a national success. But by the early 2000s, the friendship had fractured. Ferlito wanted to sell his half of the company, possibly to giants like Coca-Cola or Pepsi.
Voltaggio resisted. He believed that selling out would compromise Arizona's independence and identity. The conflict ended in court, but the central question being, what was the company really worth?
But here is what makes this case fascinating. From both a legal and economic perspective, Arizona isn't just defined by who owns it. It's defined by its pricing model. Since the 1990s, they've kept their 23-ounce cans at 99 cents, a decision that seems almost impossible in today's economy.
Yet, it works. Tea itself has a low production cost, aluminum cans are cheap, and Arizona keeps their expenses down by avoiding traditional advertising. Their branding is the marketing. The can designs are so distinctive that they're instantly recognizable.
And stamping the price directly on the can, that was a strategic move. It discourages retailers from raising prices and reinforces Arizona's image as the fair deal in a sea of overpriced drinks.
This strategy matters for the lawsuit because it explains why Voltaggio fought to keep control. Arizona's model isn't about short-term profit. It's about long-term loyalty. A buyout to a bigger company might have meant raising prices, changing branding, and undoing the philosophy that made Arizona stand out. But here's where the corporate law steps in. Because in closely held corporations like Arizona, co-founders often have restrictions on selling their shares.
Exactly. Ferlito argued his stake was worth billions. In fact, an outside valuation in 2010 estimated Arizona's full value at around $3 billion. That meant his half could have been worth more than $1.5 billion.
But Voltaggio, the other founder, wasn't having it. He didn't want outside buyers swooping in. He argued that under their shareholder agreement, Ferlito's shares had to be valued differently, more like a fair market approach, which could mean a much lower price tag.
And this launched a decade-long legal battle. Ferlito wanted cash, Voltaggio wanted control, and the New York courts had to figure out how to untangle the mess.
Okay, let's slow down for a second. What's actually going on here legally?
This is basically a shareholders dispute, which means disagreements between company shareholders or disagreements between shareholders and their management in a closely held corporation. Unlike public companies where you can just sell your shares on the stock market, private companies restrict how ownership changes hands.
Right. These agreements usually have buy-sell clauses. Rules for what happens if an owner wants to leave. Sometimes it's like the other owner gets first dibs at a set price, and sometimes it's you need to agree on a third-party buyer.
In this case, Ferlito and Voltaggio had what's called a shareholder agreement. Basically, a contract between a company's shareholders that establishes rules for managing ownership, shares, and operations. But when Arizona blew up into a billion-dollar empire, suddenly those old agreements didn't seem so fair.
In 2014, the New York Supreme Court got involved. Ferlito argued for a valuation in the billions. Voltaggio argued for a much lower number.
And the judge sided more with Voltaggio. The court ruled that Ferlito couldn't force a billion-dollar buyout. Instead, his shares had to be valued based on the agreement, which came out to something closer to $200 million. A huge difference.
Imagine thinking you're walking away with $1.5 billion, and then the court says, no, but here's $200 million. Still a lot of money, but the sting.
the legal equivalent of ordering a venti latte and getting handed a tall.
So, what's the lesson here, besides don't mix business with friendship?
First, that shareholder agreements matter. The terms you agree to when your business is small can come back decades later when your business is massive.
Second, it shows the tension in corporate law between liquidity and control. Founders often want the freedom to cash out, but other founders want to protect the company from outside influence.
And third, sometimes the law prioritizes stability over maximum profit. The court basically said Arizona needs to keep running, not collapse in a billion-dollar tug-of-war.
What I think is fascinating is that despite all this drama, Arizona Iced Tea is still privately owned, still independent, and still selling those cans for 99 cents.
Which makes me think, maybe Voltaggio's fight to keep control actually preserved the brand. If Pepsi or Coke had bought it, would we still have those massive cheap cans? Or would they be $2.49 now?
Please don't give them ideas.
Anyway, it's question time. Meva, would you make a company with your best friend knowing the consequences that could come with your actions?
I would love to make a company with you, Molly. But real talk, I think it depends on several things. When we discuss shareholder agreement, that's obviously very important. To me, a company that I would want to make would have to be private with almost zero outside influence. And that's hard to do when you have another person in the mix, especially with your personal feelings involved. I think John Ferlito and Don Voltaggio had a great idea where they came from, but their contract should have been a little more airtight.
I agree.
And now I have a question for you, Molly. Do you feel more pity tears for Voltaggio for almost losing his half of the company, or for Ferlito for not getting as much money as he originally thought he would?
I don't think I feel pity for Voltaggio. However, I definitely side with him more. But I do feel pity for Ferlito, as he thought he was walking out with billions, but in reality, he only walked out with millions, which, although still a lot, that is a big difference.
I was about to say 200 million compared to 1.5 billion. You're losing out on a lot of money, but you're still walking away with a lot.
Yeah. All right, Mela, do you think shareholder agreements are important for people to know about in general, or just for people who want to own a business?
I am a firm believer that this matters for everyone. We are two teenagers and we still need to know about all of this. Shareholder agreements don't just come up in business, they come up in everyday life, even if you don't realize that they do, much like the law.
Yep. Now it's time for Law or Nah.
Molly, please hit me with the law of the day.
In Alabama, is it illegal to wear a fake mustache that causes laughter in church?
I will say no because I think that's ridiculous.
It's illegal.
You're kidding.
No.
Okay, folks. I guess they police your facial hair in Alabama.
Only real mustaches,
Oh.
no fake ones.
Good for them.
Anyway, next time you grab an Arizona, remember it's not just a drink. It's the product of corporate law battles, billion-dollar valuations, and one of the longest-running business breakups ever.
And that's the kind of tea you can't buy for 99 cents.
Thanks for tuning in to Law in Focus. If you like this episode, share it with your friends and let us know what other legal battles you want us to cover.
Until next time, stay curious, stay informed, and check the fine print before you start a company.